basically his thoughts. He's going to share his thoughts and what we are able to take away from this. Now, Francis Gimara is the head of the African Law Practice Group East Africa in Uganda. He's a managing partner. He's a senior counsel, a reputable legal professional, and he also holds a master's in law from the Cambridge University, focusing on banking and finance law, corporate tax, and international trade law. He also holds a bachelor's law degree from Makerere University and a diploma of legal practice from the Law Development Center. He also has a postgraduate diploma in business administration from Heriot-Watt University and is a member of the Chartered Institute of Arbitrators. Many of you may know Mr. Francis Gimara. In the recent past, he served as the president of the Uganda Law Society. He's also a founder and director of the Center for Public Interest Law in Uganda. He is currently serving as a chairperson of the Public Procurement Disposal of Assets Appeals Tribunal in Uganda and is a member of the Judiciary Law Reform Committee, to mention but a few. So Francis will, after Judith, Francis will come in and share his thoughts of succession planning in Uganda and what we can take away as business people. So ladies and gentlemen, those are our facilitators for this morning. For those who are just joining us, we are looking at succession planning, what you need to know as a business person.
The quantity that is worth. So
I would like to request you, somebody, please mute your phone as you speak. We can hear what you're saying. And again, why succession planning? It's because typically we start our businesses as individuals or as family. And yet, as we start these businesses, we want to achieve a long-term legacy. We want to build a legacy. We want this business to continue. And so we thought it is important for us to get experts to share, to give useful insights on how we can engage our family members. What are the provisions? How and when do we engage family members to work in our businesses? How do we share profits? How do we distribute this? How do we get members to serve on the board? Who may serve on our board as a family business? But also, how do we plan for the future leadership of this business and many other matters of taxation and etc. that are going to be shared by Judith. So I would then like to take this honor and privilege to welcome Judith Aboto. Judith, you have the floor. Please take us through the law of succession and the implications on our businesses. Over to you, Judith. Judith, are you on? Or are you, is it muted again?
Perfect. Yeah, I was muted again, but thank you so much, Rosemary. I am back on. I would also like to start my video if that's possible, if you can help me with the settings.
Okay. Just a moment. You're not able to share?
Yes, I'm also not able to share my screen.
Try that again and see.
Okay, now it's possible.
Thank you. Okay.
Yes.
So welcome to those who are joining us, who are coming on board. Welcome. Our speaker, we have two co-facilitators. So we have Judith is going to start us on as she sets up her presentation. Judith is going to take us through what you need to know about the succession law. We have a succession law in Uganda, and you as a business owner, what you need to know. Then her colleague, Mr. Francis Gimara, a senior advocate of African law practice, is going to share his thoughts on succession planning in Uganda and what you need to take away. And for those who are just joining us, please go into the chat room and just sign up and tell us who you are, what your business you do, and share and your contact, either an email or your number, because we believe that in addition to getting knowledge, we are here to network, to build networks, because businesses grow through networks and partnerships. So over to you, Judith. I think you're now ready. We can see your screen. And so please take us away.
Okay, Thank you so much, Rosemary. So today we are talking about succession planning, as you've ably introduced. And what the purpose of this presentation is to let people, as a business owner, what are you supposed to know? What are the basics that you need to know with regard to succession planning? So I will start off with the legal aspects of this presentation, and Francis Kimara will later on join us with the business aspect of the presentation. As an overview to our presentation, we will focus on introducing what succession planning is and its major importance or purpose. And we will introduce you to what law-based succession is and principles-based succession. I will also delve into the highlights of the key amendments of the Succession Act and how they impact a business person, how they impact a business owner, and how they should be informed on how to take charge of their assets and property and businesses before their demise, and so that they can be controlled well when someone passes on. And Francis will then later on join us with principles-based succession, taking us into the aspects of a business owner, the principles that they should focus on outside the ambit of the law, and how they can help this particular business owner in taking charge of their assets and property long after they're gone. So generally, what is succession? A dictionary definition will just tell you that it's inheriting property from someone that has long passed on. So it can be property, it can be physical property or intangible property, it can be an office, or it can be a title of someone. But today's session, as we're focusing on business owners, what we're going to focus on is, as a business owner, succession in the helm of a business owner. Then what would be succession planning? As we have said, the topic is succession planning, what you need to know as a business owner. Succession planning is literally, basically, it's the process that ensures that there is a proper takeover of one's assets upon one's demise or one's passing. If we go into the details of it, it would be the process of identifying high-profile individuals and evaluating and developing their skills, so that by the time you pass on title, pass on your business, they're properly well equipped to take over it. And why succession planning is important is that it will help pass one to protect their assets upon their demise. And it seems some still here, so there is no need. I'm still energetic and I can still do the work. But as we have seen in the wake of COVID-19 and in the wake of unexpected events and emergencies, that business owner, you have set up something, you have started a business, and you've employed people, you have put up structures and buildings, and you're generating income, and that is impacting the community, your loved ones and family, and other people that are your employees. So why succession planning is important is that it helps you not only protect your asset, but also it gives a guarantee of effective stability and continuity for your business at all levels. So if, as a business owner, you properly plan for your property as a business owner, if I die right now, who is going to take over my business? Who will be now known as the owner? Who will be now known as the managing partner of my business? If you do that, then you are preparing and holding your business strong and not waver in case of any emergency and any unexpected occurrence that might occur. So that is why it is important to plan for the succession of your business, not only your business, but also your personal assets. So why I'm moving between past business owners, some of us are having unregistered businesses that are sole proprietorships. You're the only owner, you're the sole owner of this business, and you are running it on your own with the assistance of employees. While others have businesses as business owners, but they're registered. So they have gone ahead to register companies or register partnerships. So as a business owner, it's impertinent that you plan for succession of your own personal assets, be you a sole proprietor, or of your business assets that are registered. So as earlier stated, I would be taking us through the law-based succession. So the law-based succession is premised on the guidance of the law. It's premised on what the law states, and you are guided by what the law states in planning for your succession. So for instance, some of us business owners operate under sole proprietorships. A sole proprietorship, you are the only one. You're the only owner of your business. You're not sharing any interest or ownership in your business with any other individual. So while you operate a sole proprietorship, all the assets of your business as a sole proprietorship are governed by the Succession Act of Uganda. So because this business is yours, if you're running a kiosk and it's you and you haven't registered it, that is a sole proprietorship because you're the only one in charge. You haven't registered it as a separate entity, a legal entity, let's say like a company. So that is guided by the Succession Act. And there is a way upon your passing, there is a way that the law will treat that property. If you are running as your business as a partnership, let's say, Judith, I have formed a partnership with Rosemary, and we have registered it with the company's registry. Upon my passing, there will be a way that that property will be dealt with under the Partnership Act of Uganda. If we decide to form a company, and I'm a shareholder in a particular company, and upon my passing, the shares that are attributed to me as a shareholder will be dealt with under the Companies Act, and it provides guidance for that. So I'm going to be focusing on most especially sole proprietorships as business owners. And Francis later on will join in and to provide guidance and steer us through the principles-based succession. That's the ambit of the business. So in providing guidance on how the Succession Act takes charge and provides guidance on handling or how personal property is dealt with upon one's passing, I'm going to focus on the Succession Amendment Act that was recently passed in this year. And it was amended to align the law of succession in Uganda with the international conventions and the position of Uganda. Mostly because the previous Succession Act sort of had aspects of gender inequality, it had aspects of a high age of minority on who could take over or who could be an executor of an estate. So the Succession Act, the recent amendments to the Act, have increased the age of minority from 21 years to 18 years. And this change has helped, it should inform you as a business owner or as a person generally, as an individual, that right now when you're planning for takeover of your assets, you can appoint someone from 18 years and not as early as 21 years. Previously, the Act had an aspect of illegitimate children and legitimate children, and they were treated differently. So currently, right now, once you pass on, be it that as long as you are taking care of people, of children in your home, be they considered legitimate or illegitimate, the Act, the law on succession will treat them on an equal footing. That is, if you have not provided details down in your will to treat them differently. But if you have not written a will and you've left an intestate estate, that means the Succession Act, the law on succession, will consider both your legitimate children and your illegitimate children on an equal footing. So as I said earlier, that previously there were aspects of gender inequality and terms where it would be a woman only inheriting from her husband or taking on property of her husband. The Act has now been tuned to have gender neutral language, whereby anyone now, it has replaced from married woman or woman to spouse, and from man to person. So that means now it has been opened that even a man, a male spouse, can inherit from his female spouse. It was not obvious in the previous Act, but now it has been made obvious to that extent. It has also replaced derogatory language, for instance, where they would call people dumb, people, children or persons with mental illness, and replaced more favorable language in line with the international conventions. So the other aspect that the Act has brought in, it has made changes to how an estate is distributed of an interstate. So why I'm emphasizing this is that I'm going back to the element of this discussion, is that what do you need to know as a business owner? If we go back down to the hallmark of all this discussion, is that you need to know as a business owner that if you do not take charge of your assets, if you do not take charge of your property, if you do not take charge of the succession of your business, the law is going to do it for you. The law is going to determine who gets what, which percentage is accorded to who. Is there a customary heir, they will benefit. Is there a dependent relative, they will benefit. So if you do not sit down and plan through preparation of a will and through putting in place structures and documents in place before you're passing, then the law is going to treat your estate like this. If you are survived by a spouse or a lineal descendant and a dependent relative and customary heir, the law will accord your spouse 20% of your property. The law will give 4% of your property to your dependent relatives. The law will give 75% of your property to your lineal descendants, and the law will give 1% of your property to your customary heir. Now, in some instances, these are people who are not well equipped to handle your business. In some instances, these are people who are not interested or do not have the passion for managing your property. But since you have not properly planned for and put in place a good succession plan for your property and your assets, the law will just distribute it in this regard, without regard to your wishes, your personal wishes, without regard to who is mostly able, who is better able to handle your affairs. And this particular table breaks it down to, if you have a surviving spouse or lineal descendant or dependent relative and customer heir, that's how it will be done. There are instances where you don't have a surviving spouse, but you have and you don't have a dependent relative. Your lineal descendants. Lineal descendants are children, grandchildren, anyone below your line. They will benefit from your estate. And these might not be people that you intended to benefit from your estate. Maybe they have not been taking a role in your affairs, but the law will decide for you. So in the distribution of or handling of an intestate estate. An intestate estate is that where the owner of the property passed on without making a plan on how the property would be taken over through a will. And your residential property, as we can see here in section 13, is that it shall not be distributed at all, but it will devolve to the surviving spouse. If you've left your husband or wife on earth, they will take it on, and your children who are normally resident on the property. If there are instances where you have left minors, children below 18 years, or others who at the time who are above 18 years, but they're below 25 years, they are taking studies, they were not married and they were still under your care, they will, the 20% of your property, of your estate will be placed in trust to continue taking care or providing for these children that you've left behind. So as we see through how your property will be distributed, how your property will be handled and dealt with, that is the law deciding for you. That is the law deciding that this is going to go here, this is who is going to take care of these minors, this is the amount that is going to be given to the children to continue taking care of them. And in such an instance, you are left out, you are not included. And the plan that the law will do for you might not necessarily be the best for you. As we see here, it's a general standard. It's even though you have an estate worth only 100 million, or if you have an estate worth billions of shillings, or if you have properties in different jurisdictions, the law will treat them equally. Yet, if you were the one who had decided to sit down and properly plan for your estate, then all these you would know who best to give what, who best to take over what. For instance, if you plan for your estate knowing that you still have minors and children that need to be taken care of, you would appoint a guardian. However, if you don't appoint a guardian for your children, under the Succession Act, Section 44A, 44B, they say that a statutory guardian can be appointed for you if they apply. And the person can apply for take guardianship over your children, yet they do not have the best interest for your children. And maybe they're only interested in having the assets that come along with the position of being a guardian. There is also an element that is brought in for separated spouses. Well, previously, if you were a spouse, you would take interest by virtue of being a spouse. But now, under Section 17 of the Act, it's saying that a surviving spouse of an intestate shall not take any interest in the estate of the intestate if at the time that the spouse dies, they were separated. So this is a new aspect that the Act is bringing in, but there are exceptions to this. So sometimes, if we are to go back to real life, sometimes you might separate with your spouse, but there are you either have businesses together or you have properties held together and children. If you do not sit down and decide what will be done, then, or maybe that spouse is a crucial part or element in your business, the law will make the decision for you. So there is a difference between how an estate that has not been properly planned for is managed compared to that that has been properly planned for through a will. So once you make a will, the law manages your estate in accordance with your wishes. However, there are certain aspects that have to be taken note of to make sure that in how you're drafting your will, it is in line with the law so that it's not declared void and it's thrown out or challenged in court. So it is important that when you are preparing your will, you are in line or you bear in mind what matters or the aspects or the factors that might make your will void. And these include fraud, they include duress, they include undue influence, they include coercion, they include any time when you're making a will and it's possible that a person who has been given a large portion or a huge beneficiary in the will has a position of influence over you that can make your will void. But in all this, what it comes down to is that while you make your will, then your estate is going to be managed in accordance with your wishes. If you have a sole proprietorship, it will be managed in accordance with your wishes. If you have shares in a company and instead of all the shares going to one person, you wish them to be held jointly by the different family members, you will be in charge of that. Well, if you do not do that, then the law will decide whether that will go to 1% of that will go to a particular person that it may be a linear descendant that you might not even have a relationship with or might not know anything about how to handle your business. In handling a tested estate, the people that you appoint in your will have to go to court, apply, and manage your estate. So while the law protects you in such a way that there is an offense that has been created for mismanagement of an estate. So once you provide a will and the people that you have named as executors to manage your estate go ahead and obtain letters of administration for your estate, they have to manage and distribute the property in accordance with your wishes. However, for those who have been granted letters of administration over an estate that did not have a will, they have to manage it in accordance with the Act. And in managing it, the Succession Act has placed guidelines that they must follow in their management of the estate and in their administration. And they even give timelines that a person cannot administer an estate for a period exceeding 2 years, unless that period has been extended by a court of law. And it also provides for instances of joint administrators. So if you are not certain and you are skeptical about leaving the entire management of your entire estate to one person, you have the ability and the right to choose 2 people to manage your estate for you. So why are we going through all this? This is to guide you in the importance not only, but in how you can plan for any unforeseen eventualities, because we all have a limited time on earth. And there will be a time when all the toil and labor that we worked for while we are here on earth will have to be left for someone else to take over and to handle and to manage. And with the law, the succession law in place, it helps and helps your wishes be realized long after you have passed on. But not only that, if you have not prepared on how to handle your business, on how your business should be handled, on how your personal effects should be managed, then the law will also still protect you and provides mechanisms for how your estate will still be handled in the best way possible. So we will then now go into the value of succession planning, which will be in line with the principles-based succession. So now this is where I'm going to hand over to Francis to take on with our discussion. He will guide with the aspects of business while that are outside the ambit of law. This will be more practical. Thank you.
Thank you very
much. Thank you, Judith. Yeah, thank you, Judith, for the presentation. Thank you, Rosemary, and everyone on the call. It's a pleasure to speak to you this morning, and indeed a privilege. I will continue to discuss this point. You know, we structured this talk to take benefit, as Judith has ably elaborated, on the new law. Now, when you are doing succession planning, I know that there are many ideas out there about how this is done, but we have to be very unique to the Ugandan situation. The Ugandan situation is such that many businesses are birthed, but many die with the owners. I think that has been restated. And the Ugandan situation is also tied a bit to culture. There are many people, many clients I talk to about estate planning, about planning succession in your businesses, and they just don't want to do it. They just don't want to have a conversation on anything that is near death. So it's also those cultural inhibitions. But like we've said, that there is value in succession planning, both at an individual level as well as a business. At an individual level, because most of the businesses we have today are owned by individuals. You know, sole proprietorships, then we have partnerships as well. And that is where the majority of people are doing businesses. Now, the importance of linking that to the Succession Act is really to restate the point that either you are going to plan your succession, even business-wise, or the law is going to help you to plan that for you. like Judith has stated, unfortunately, when it is coming to the law, there are those provisions already in the Succession Act. They will guide your administrators on how even your business is managed. Now, the challenge is that if the business has been inherited through the Succession Act, it is not automatic that the administrators and the settlement of the estate will take into account, you know, the journey of your experience, the journey of an entrepreneur, and how you have built the business. The two are not synonymous. And that is why you need to have a rethink that what happens if, you know, these two don't connect. It's not automatic that whoever is going to administer your estate will do it in a manner that carries your business vision. And that is why it's important that you think about these issues very critically. And the reason for this also is as a result of COVID. I mean, COVID reminded the whole world how vulnerable we are. As we deal now, as we speak now, I am doing a study just in the family court on the effect of COVID deaths on estates and how disruptive that has been to the businesses. I hope that when I'm done with it, Rosemary, I will return to share those findings, because so far what I'm picking up, they are very interesting signals for every entrepreneur to take benefit of. But there is value. Let's really restate that there's always value in succession planning, because you are in charge. You ensure that there is an orderly transfer and distribution of your estate, such that you will then concentrate on ensuring that the tree that produces the fruit is not destroyed. You know, your beneficiaries can continue to enjoy the fruits of your business without destroying the tree and the roots. So succession planning should be looked at in that context, that you have planted a tree, it is firm, it is deeply rooted, and it is grown, producing fruits. You have to then ensure that whoever takes over the fruits continues to enjoy the fruit without the destruction of the tree. So it is important. And also without properly planning for who to take over from you, the law will decide with you. And I've already said that the law will sometimes is not synonymous or in line with the business issue. But also a lot of data, and we've looked at that. You know, just some of you watch CNN regularly. One thing that always intrigues me is these tips about companies that have spent more than 100 years. They come and just share a brief story, how that company started and all that. Those 100 years have been possible because of effective succession planning. And indeed, data and all the business data that is available show that there are demonstrable benefits for undertaking effective succession planning. Some of them include business growth, business profit, increased profits, then of course as well savings on rehiring costs, because you imagine that every time you plan and somebody leaves, you know, looking for a bigger challenges, you have to rehire, but sometimes your company has reached that level where you don't have the energy and the time to hire a junior person. You have to hire somebody senior, somebody more experienced, and that comes with costs. Then importantly also, it helps you develop a pool of leaders, you know, at your disposal, who can be called on anytime to support the business objectives, you know. But let me move and discuss generally from a business angle. And I again say this because we cannot exhaust succession planning in the time we have. We'll only touch on the law as it is, but generally share with you a framework that you can use or you have looked at that generally speaks about succession planning. But importantly, as a business person, speak to a sound, you know, expert about these issues, you know, just on succession planning. And the experts will share with you that generally when you talk about succession planning in your business, you are basically asking the following questions. Talent acquisition. Are you hiring and building external pools that align with the future needs? How are you acquiring your talent? How are you, you know, identifying unique talent that can boost your business Are you in the market? Are you attentive to people, to young people, to future employees who, are very aligned to the future needs of your company? So it all starts with the vision. Where is your vision? Where are you going? And how are you acquiring the talent to support your vision? And it's not all about talent acquisition. You must also be able to intentionally, have an onboarding and engagement strategy. Are you facilitating relation building on the onset of employee tenures? When your employees come, are you just there, I pay you a salary, that's it, do your work? That alone, as you know, the non-hygienic factors of motivation. Sometimes it's not about the salary. Sometimes it's about the other benefits, how you treat a person, how are you onboarding them, how are you engaging them, and those sorts of things. Then also importantly, in this country especially, as you'll see from many studies, it is very rare for you to get an employee who is 100% ready for you. Many times as a business owner, you will be called on to develop your employees. In fact, I think it is Jack Welch who says that sometimes I will, as long as an employee has a good attitude and they are ready to learn, I would prefer to onboard that employee as opposed to an employee who is an expert and has a bad attitude. Why is that important? Because you must think today, when you are dealing about succession planning, that you have to develop these people. You have to develop your employees to succeed you. They may not be like you, but they will benefit from your journey. They will benefit from your experience. They will benefit from you handing over that baton to them properly so that they can continue with the rest and hand over to the other person. Then, of course, you have to think about retention. You cannot leave that hanging. How are you going to retain that star performer, that employee who is good in performance, but also who is good, in terms of potential? They are very big on potential. They are willing to grow. They are willing to develop. And then also they are very good on performance. They perform well. They give you the results. You must intentionally think about how you are going to retain them. But also if they leave, always leave a room, for your employees to return. I always tell my senior leaders at ALP that even how an employee exits is important. For us, we sort of create an ALP academy or alumni group. When you leave, we put you there. When we have functions, you come and attend. When we have our unique functions, we invite our former employees. Why do we do that? Because an employee may leave, for a short while and return, and they're good star performer. So it is always important that if somebody has decided to leave, you find out why they have left, and then engage them and exit them properly, do a proper exit interview, but also keep that friendship because they may return to you. And when they return, they will be able to then fit in very well. Then of course, succession planning cannot be, undertaken without performance management. It's very, very important that you ask the questions whether your managers are being held accountable for developing leaders. I routinely ask my team leaders, who are you developing to replace you in case something happens? That conversation, you must have it routinely. If the team leader or head of department is not there, then what happens? So I have required that most of my team people build the people they work with so that they have, that relationship and they are holding them accountable as a means of ensuring that there is succession. Then of course, you always have to think about workforce planning, okay? Are you identifying successors who align with future business requirements, values, and vision? So when you talk about successors, you must always have that workforce planning. You must be in the market, you must be attentive, you must be listening to what your rivals are doing, what they are doing well, and learning from them. And also importantly, always remember that effective succession planning is about effective people management. Many times we think that it is the capital we have put in the business. Somebody starts a restaurant, injects 200, 300 million shillings, and then they are treating their employees badly. And the feedback we get as customers is that you attend and you are purchasing from a very unsatisfied customer, and you're somewhere in town doing other things, and you're a business owner, you have left people, a supervisor in charge, but you are dealing with a very unmotivated employee who is interfacing with the client. What do you expect that the client will do? That will be their first and last time. So you can imagine if you run a restaurant and you have employees who are motivated, who are on spot, who feel that this business is theirs, they are part of it. They will serve the customer and they will stay. You will make more money, and then also your people will grow. Whichever way you look at it, it's very helpful to the business. Now, like I said, succession planning is very long, but let me just say the most important things, when you are dealing with succession planning. And I am very alive of the fact that on the call, we have sole proprietors. On the call, we have people who are shareholders, also managing directors, and also business owners. We also have, people who are running businesses as partners. Whichever way, when you are dealing with succession planning, the most important thing to think about is to look at the position. What positions are you going to be very intentional about, being succeeded in? How are we going to map out the positions where you have to be intentional about succession planning? It is important that the position is identified. If you are the sole proprietor of a business, who is going to succeed you? That's the position. Is the business going to end with you? Those are questions that you must ask, And then when you have clarified on the position, then now, like we've said, look at the participants. And I've already shared roughly what that would be: identification, deployment, and development. But be very keen on the participant you choose. Be very intentional that the person you are choosing, for sole proprietor, you may even have children, and you want one of them to succeed your business. And it is important that we as parents also attend to the unique needs of our children. I say this because many times we are just after defining the future for our children without taking into consideration their unique gifts and designs. It's just like the parish development model. You can't just give money without developing people who want to do the business for which you are giving money for. So children are unique. Each child is very unique. So if you're a sole proprietor, within your children, you have to identify that if one of them is passionate, they are good at keeping money when they are young, they are talking about businesses, they love to come to see you at work, they love to stay with you at work, be sensitive to the unique design of your children. So that when you then get that participant, or if a company, you're looking at that employee, like I've said, who is big on performance, big on potential. And if it's that participant, then prepare them, Prepare them. Preparation is very, very, very important. I say this because I have been able to painfully see estates and businesses being wasted. Where I sit as an advocate, I have seen businesses collapse with the owners. I have seen the children just come and say, find somebody, sell, I want to move out, So preparation is very key. And intergenerational wealth is maintained by how effectively you prepare the next generation. I have been keenly studying the Indian model. Just here in Uganda, you have seen this and you'll agree with me that the Indian, when he has a shop, his children will be seated in that shop. The Indian, when he's running a business, the family will be involved. Why do they do that? They do that to intentionally prepare their children to assume business when they demise. You remember many years ago, those of you who remember, I was reading a Saturday Vision and I saw an interview of Sudhir about his son. You know, he was saying he had to send him to London to work with other people and do taxi driving so that he appreciates how business is run. Today, you see them seated and walking with the father. Why? Because he recognizes that time will come and the son will take over. And if a son takes over such a huge entity like Mera Enterprises, without knowing the intricacies, without knowing how the business is done, without knowing who is important in the business, without knowing, you know, the market, it will be difficult. So preparation is very important. We have not done well as African businesses, but we have Mulwana, thankfully. We see that the business has moved to that generation. We see the Sekalaras. We see that there is some form of, you know, involvement. Aga is picking up very well and even growing the business in a much admirable sense. So what does that show us? It shows us that when you are intentional, you bring the children in, those who show interest in the business, send them, you know, develop them, send them to do business courses, send them to sit with business people, send them to, you know, empower them, make them read, make them go and sit with Rosemary as interns there to understand the different businesses in the country and how they are run. That development is very critical. For the company as well, you have to embed this in your human resource manual. You know that there is an intentional development of those people who need to succeed you. Then, of course, you have to monitor. It goes without saying that what is not inspected cannot be expected. If you don't inspect something, you cannot expect it. That is a saying we are all familiar with. Especially here in Uganda, you have to monitor consistently that your plan and your succession plan is actually producing the results that are so desired. And when you do that, then you are able to effectively implement your plan. So I want to say that succession planning is a must. Somebody once said that there cannot be success, you know, without a successor. That is true in anything we do. So as entrepreneurs, as business people, let us be very alive to this fact. You know, for me here, when I sit here with Judith, I am implementing my own succession planning because Judith is second generation ALP. So tomorrow, if Rosemary cannot find me, we'll find who? Judith. So it's important that we are very intentional about these things as a business, because when we do them, then we affirm them and they help our businesses grow. I'll end by saying, quoting one of my favorite business leaders and writers, John C. Maxwell. He says, a leader's lasting value is measured by succession. Your lasting value is measured by succession. We want to see that today, 50 years from now, 100 years from now, that your company is existing. We want also to count indigenous companies that are 50, 100 years. And the best way and the only way you can do it is through effective succession planning. So I wish you well and thank you for listening to us. We will cede now and take questions, because questions help us to explain much better. Thank you, Rosemary, over to you.
Thank you very, very much. I must say, I should just say, wow. Thank you so much, Senior Counsel Francis Gimara and Counsel Judith Aboto. I think this has been excellent. for those who joined us a little late, today we are talking about succession planning, what you need to know. And Judith ably took us through the legal aspects of succession planning. And I think she underscored the importance of, if you have your assets, you had better will them, because if you don't will them, the Succession Act amended in 2022 will take care of the distribution according to the law. And so if we've taken so much time in creating our assets, I think it is important that we plan for them. And so thank you so much. And then Francis comes in and gives us the business aspects, the business side of succession planning. And he has shared with us, I'm excited about that, the pillars, the 6 succession planning pillars that you just shared in business, Advocate Francis. And so it is out there. Talent is important. Retention. How do we develop our employees? Performance management. I think there's how would we onboard our staff? How would we get staff on? What systems and procedures do we have? Are they written? Are they known? Does everybody know them? And then, of course, workforce planning. We just don't randomly recruit. We need to have a strategy that is in line with our vision. So thank you so much for those extremely important insights. And so I think that I would now want to open up for questions. And so as we usually do, please put your questions in the chat group. But you can put up your hand if you have a burning question. Other than that, let's put them in. We'll take a couple of questions, and then I'm now going to the chat group to read up questions there, and then we'll then ask our 2 facilitators to respond to those questions. So go into the chat room and put your questions, but also to say, the facilitators are going to share with us this presentation, and so we will be able to email to you. If you, in your registration, I hope you gave us your email address. We shall share with you this presentation. Okay, I think there's already a question in the chat from Rebecca. Rebecca is asking, she says, thank you, Judith. If I have some children I stay with, these are children of relatives. Their parents went abroad to work. If I stay with these children for over 5 years and just by bad luck I die, are they also entitled to my property? That's a question from a very valid question from Rebecca. So any hand up? I'm scrolling through to see if we have any question. How do you, Paul Tusingwire says, how do you handle division of land for a farm between your children? Yes, I think those are the 2 questions that we have on the group here. So ladies and gentlemen, please post more questions. I'll then ask our facilitators to take on those 2 questions that I've just read out. Over to you, Judith and Francis, as we wait for more questions.
Thank you so much. So regarding the first question of the lady who is living with the children.
Judith, we can't hear you. I think a bit of a disruption in your internet. Please, could you just begin that response again? Thank you.
Okay, sorry about that. I hope you're able to hear me now.
Yes, now you're on.
Yes. Regarding to the first question of the lady who is living with children of her relatives, and the question is the relatives are abroad and whether children of the relatives can benefit from her estate. Well, with regard to the law of succession, they will not automatically benefit from your estate unless they are regarded as dependent relatives. So if they advocate that they are dependent relatives, they are dependent on you, and unfortunately you don't have a will, then they will be considered. However, if you have a will and you do not provide for them in the will, then they will not be considered.
Okay, that wasn't very clear. We didn't still hear you that well, but I think what you're emphasizing here, that whatever your wishes are, put them in the will. If these children are living with you, they will be the law will consider them as your dependents. So if you feel they are not your direct dependents, then I think your will should take care of that. Okay. The next question.
The second question, I hope you're able to hear me. The second
if you can speak.
Francis will handle that one on handling division of land.
How do you handle division of land for a farm between your children?
Yes.
That depends whether you have died tested with a will. You can decide. The beauty with doing a will, and we invite you really to make your wills. If you want formats, Rosemary, LP can circulate formats and you do them with your own trusted people. We can share with you a format based on the new law. But it is, and the reason for us is that we have seen, the pain of not doing a will. So, Paul, it is impossible. How you handle sharing is to determine it now. Some people prefer that, you divide the property now so that I go without any issue. I say, I have 2 acres of land. I am giving each one of you a quarter of it. This is your portion, this is your portion. And they go ahead and do it while they are still alive. Or they can still do the same thing tested, that is through a will, so that the executor at the point of implementing the will divide according to your wishes. That is if you want to take that route. Now, if you don't and you die intestate, meaning you die without a will, then the law of succession, like Judith has stated, will be followed. There are percentages for children, there are percentages for, dependents, and if they're only children and spouses, all those percentages are provided. And we'll share with you the presentation so that you can, at your time, look at that critically.
Thank you very much, Francis. We'll take on now a couple of more questions that are in the chat room. And thank you for offering to share the will format. I think that is very important. And please just confirm to us that it's a simple thing that one can sit on their computer and actually be able to produce on their own, or do you still need to carry that will and take it to a lawyer, pay some fees, and have it completed? So I think you may want to throw some more light there. So Harriet Musoke is asking, are there appropriate courses you recommend for children who have taken over their parents' estate, their father's empire, and they are more than 3 shareholders? Julius Adupu is asking, as an employee, how do I position myself as a participant for succession? And that is a question to Council Francis Gimara. 2, can a will be amended from time to time, considering that we grow in assets and wealth over time? Question to Council Judith. Jacqueline is saying, okay, she was asking for, she will need the slides. Yes, these slides are going to be shared. As long as you have registered and we have your email, we will share these slides with you. Simon Adobo Ochen is saying, hello, advocate. I'm running my company, but I don't have family yet. I have no wife and I have no children in our family. I'm a stepchild on both sides of the parents, mother and father, both demised. Grew up with my auntie. Just in case I died now, God forbid, who would take over my property or company? That's another key question. Okay, I think that I'll let our one last question from Kaduyu Abdallah Mwije. He's saying, does anyone have an idea about what percentage of Ugandans with businesses who know about this information? Is it translated in other languages for those with businesses but never acquired formal education? Okay, so over to you, Council Judith and Francis Gimara. Please, let's take that set of questions, then we'll take another set. Thank you.
Okay, so I will start off with first on whether a will can be amended. Yes, a will can be amended, and that is why it's usually very important to date the will. So once you can make a will, I can make a will, let's say I would have made a will in 2019, but in 2021 or 2022, I amassed more properties. I will amend that will. I will create a new will and include the property that has not been included in the previous one. And 5 years down the road, I can create another one. It is best to refer to the previous will or revoke the previous will to say, I know that I made a will in 2019, but this is now the current will that should be considered. Please disregard the other one. So yes, it's possible to amend the will. For the next question that was on the aspect of no surviving, no spouse, no surviving dependent relative, and no parents. Well, if you prefer and you have, let's say, wishes of certain people taking on over your property once you pass on, then it is best that you name or list down these people within a will. If, however, you do not, and unfortunately, you pass on before drafting a will, then the law will decide how your property will be distributed. And the law makes provision for where a person has no surviving spouse and has no dependent relative. In that instance, or in such a situation, linear descendants will get 99% of your property. So who is a linear descendant? A linear descendant is one who is descended from, is below you, let's say in a hierarchy of the family, is below you, and can include a child, it can include a grandchild, it can mean any person that is related to you in a descending line. So it does not really have to be your own child. A linear descendant can be anyone that is below you in the family hierarchy. So if you have sisters or brothers and they have nieces in that line, they will the law will accord them 99% of your estate.
Wow.
On that issue, I think, Ochen, I would recommend you do a will. You know, there's a saying, Vasimo Genze, your estate may land into somebody you did not plan and to have it at all. But, and I think that's the beauty of this exercise, because you see, a will that is not complex, Rosemary. You sit down, the document we will share for you, with you, is just a format, but it will guide you, you know, and you can write it, put in your wishes. The only way a dead person speaks is through a will. The only way you can speak from your grave is when you write a will. And that's why it's important that you know, you write your will and detail how your property should be shared, especially when you may be in a situation where you don't have a family that is anchored in the terms that we all want a family to be anchored. So it's important, and I emphasize it again, do a will. It does not cost you anything. You don't have to have lots of properties. Sometimes even just on how the small things you have at home should be handled. So it's not contingent that I need to have this money in my account. I need to have it just to be organized as an individual. You know that when you pass on, there is no drama. Around your death, there is no chaos. Everything moves on well. It just demonstrates to the people who have escorted you that you are really a very organized person. And that is what a will does. Now, Rosemary, you asked about this will. You can do it on your own, but there's always a value, of course, having a lawyer look at it, you know, to advise you that what you have bequeathed in your league is legal. For instance, you may already have given the property, but you still are writing it in the will. There are some legal issues. You know how to witness it, and there are some requirements that in what state have you made the will, how the witnesses to the process, all those are legal requirements. So it is, you can still do it, but it's important that thankfully we now have many lawyers. Almost every family or cousin there is somewhere who can even they was just left law school, can look at the will and tell you. But as long as you trust them, that's the key thing, that they are not going to leak the information and put you in danger when you are still alive. Because the beauty of doing it with trusted lawyers, older lawyers, experienced, is that they will keep the secrets, you know, in the will without telling anyone. You know, because nowadays also you just don't know how children are. You may have one errant kid, he knows that, you know, you have willed him a property in Kololo and you are delaying to die, you know, and he can do anything, you know, the people can do anything. So you just have to be organized. Courses for children who have taken over business by their father, I think these courses are available, you know, like attending such talks, you know, enrolling with business schools. You can even do a diploma in business management, you know, or in your own time, but it is important to be equipped. There are also so many courses that have opened online since COVID started, you know. You just have to get on and assess your training needs. Is it finance that you need? You know, if you have 3 children, if one is managing finance, another one is managing customers, and another one is managing operations. So you can say, okay, you go and do a customer care training somewhere. You are doing finance, at least get a small course, you know, financial management for non-finance people. I think they're organized by many, many entities. So those are available, but what is important, undertake your own personal training needs assessment and then identify who can supply that training and course for you to be equipped. But it is a good question because being equipped is very critical. Now, the employee who wants to be up there in the succession line, it's possible. 2 things you must be big on. One is performance. You know, you must perform, you know, to your greatest extent, such that everyone notices that if you are not there, there is something wrong. So 2 things: perform and outperform your performance targets. 2, demonstrate potential. You demonstrate potential by developing skills, you know, have a good attitude, have other skills beyond your job. Because even if you're a good lawyer, you know, and you're very excellent, I'm giving an example as a lawyer, and you have a first class, you are very good in writing legal opinions, it's not a must that you will actually be a managing partner of a law firm. Why? Because managing partner of a law firm requires you to have other skills. You must know how to manage people, you must know how to manage clients. So that is why, on top of being good in performance, do also develop the skills beyond your office so that somebody can see that you are an all-rounder. At the end of it all, you must grow as a leader. So I think those are the questions. Rosemary, over to you.
Thank you very much, Francis and Judith. We'll take on the next set of questions. And like you've said, I just want to add on to that for those who want to get more knowledge. I think attending sessions like these are very useful, but also as Enterprise Uganda, we run these clinics weekly, but we also have other business clinics where we touch on some of these small topics, preparing you how to run business, to understand business, because essentially being able to further somebody's estate requires that you have a business mind and you understand business and can do it. So you can come to Enterprise Uganda as well and check on our menu of services and trainings that we have and see what can be useful to you. It may not be necessary to go for a formal training, because what you now need is really practical knowledge on how to further this estate. Okay, I'm back into the chat room. We'll take more questions. Daniel Katoche says, supposing someone writes a will and he didn't share all of his property, I think at the time of, he dies suddenly and hasn't updated it. Who is responsible to share the balance? Please advise accordingly. Susan Kasule says, what happens if one dies and has left a will, then 5 years later, some children and their moms put caveats on that will. Technopops is saying, today I was discussing the issue of employee retention with one of my employees, and I'm sure now definitely Francis's presentation has given you more insights on how you can tackle that. Kindly answer the question Rosemary asked about the process of writing a will, including relevant parties involved. That is Peace Masco asking. And then Simon Adobo Ochen again is saying, have the mother, it's the father who is demised, but mother married to another man. I think, how do you handle a situation where the father passes on, but the mother is married to another man? I hope you can make sense of that, Council Francis, and respond to that. And then Jacqueline is asking, Jacqueline Navisanja is saying, where do we keep the will after the will is written? So I think that, Francis, you need to take us through the steps, the procedure of will writing, and from the start to the end, some of the key steps that are, so that people understand exactly what is involved. And then I think we'll take the last one from Winnie Karunji saying, is there a further definition of separated spouse? Just like we got a breakdown of lineal descendants and dependents. So I think over to you, Francis and Judith, please take those questions, and time allowing, we'll take one last set and then we'll be closing this session. Thank you.
Okay, Judith will answer on the provisions regarding a separated spouse and exceptions. And as well, she will deal with the other question from Simon, and I will deal with aspects of the will.
That instance comes in, let's say that by the time of one's passing, they were married, they are married to a particular, they are married to someone, but at the time of their passing, they are not divorced, not that they're divorced, but they're not living together, and they are not still, how should I put it? They are not on, let's say, good terms. They are not living together, but they are not divorced, an aspect of separation. Or they could have gotten a judicial separation decree from court. So at the time of one's passing, they are separated from their spouse and they have died intestate. The law says that the separated spouse cannot benefit from the estate. They cannot take any interest in the estate of their spouse who has passed on by virtue of the fact that they had separated. What are the exceptions, however, that the law says? If you have been absent from your matrimonial home as a result of an approved course of study, let's say you are not with your spouse because you have gone for further studies abroad, or the intestate is the one who separated from you. You still wanted to live with the intestate and your residential matrimonial home, but the intestate is the one who decided to separate from you, or they are the ones that have caused the separation. So in that instance, if you're not the one who institute or started off the separation, then you will benefit or take an interest in the estate of the intestate. Or if you're separated under cordial terms of, I have to go for further education or I have to go and study elsewhere, but you're still regarding them as husband and wife, as your husband or wife, then you will still take an interest in the estate. The other aspect was on the gentleman who has a surviving mother. It's the father who passed on, but the mother is married to another person. The law, if you pass on intestate, it depends on whether you want to provide for your mother. If in that regard you want to provide for your mother, then would advise that you in the will indicate that and pass on property to your mother. However, if you pass on intestate without providing, making provision, then the law will determine whether your mother is a dependent relative. So since your mother is not a lineal descendant, is not descending from you, they're above you, that means they cannot be regarded as a lineal descendant. The law will ask whether your mother is a dependent relative. So if she has been depending on you for provision, then she'll be regarded as a dependent relative and will benefit or take an interest in your estate. Yes.
Thank you. On the challenge, I will run through issues of the will and try to unpack the time possible as much as we can on generally the law governing will practice. The key point, I think, somebody asked if people came 5 years later. Now, under the law of succession, if you have a limited time to
Francis, we keep losing you. You're in and out. Maybe
can you hear
positioning. Me? Now we hear you.
Hear
okay, now we hear you.
Somebody asked about the possibility of challenging the will 5 years after. That's not possible because the law gives you 14 days to challenge it. The reason you see those notices being put in newspapers is for you to challenge anything to do with the will or anything to do with the estate before either the letters of probate are granted for a person who has died with a will or letters of administration in case the person died intestate, that is without making a will. So 5 years later, you will be caught up by the law because it will have departed from the procedure umbrella in which you are required to challenge anything under the will or the estate. Somebody asks about keeping the will. The will can be kept in several places. The law recommends the following. The chief registrar or deputy registrar of the High Court and can keep it. The advocate, your personal lawyer, can keep the will. The bank can keep the will if your banks keep wills routinely. Then also a trusted person, somebody you really, really trust, and that is somebody who will not open the will before you die and begin giving people information, somebody who cannot conspire against you, somebody with a clean heart, somebody who has you, who you trust 100%. Some people choose bishops, others choose reverends, they are pastors, imams, but it has to be a trusted person. Those are the recommended places. When does the will take effect? Until the testator dies. That's when it takes effect. And then there was also a question of the process of writing the will. In making the will, there's generally no statutory or general form, but the law provides contents of a will, and that's what we've promised to share to you. If you shared with us your emails, because we will pick it from the 4th schedule of the Act and unpack it for you gratis as our contribution to the entrepreneurs of Uganda in creating jobs and running the economy. ALP will send that to you, and then you look for a trusted person and you make your will. Of course, when making the will, please take note of the following. You must have 2 witnesses. Because if the will is not valid, then the law will presume that you died intestate. So making a bad will is similar to dying without one. So you need to take, you need to cross all the T's and dot all the I's. Have 2 witnesses with you when you are finished making the will. These witnesses, what is their job? They must see you signing the will, okay? That you have signed in their presence. That's their job. Do they read the will? No. They are your witnesses that I was there when Rosemary signed this will. I saw her and I also signed after her. And this is my signature. The purpose of this is to enable, if somebody challenges the will, to enable those to become your witnesses appointed by the law to confirm to any forum where the will is being challenged that indeed they saw you signing. So you need two witnesses. It's not a must that they must see the contents of the will. In fact, it's advised that they should not. They just see that you signed and they sign. Okay. So that is really, and you must sign every, there is, the signature takes many forms. You can imprint your thumb or sign if you can sign, but also you must sign at the end of every page of the will, you know? You must sign on every page. You don't sign on the last page alone. You must sign on every page. Some people even take it a step further by signing every clause, every paragraph of the will. But the law says every page, okay? What else should I tell you about that? Your statement of the mind is also important. The state, you cannot sign or do a will, and the law now has strengthened, you know, grounds for invalidation of the will. You must be in sound mind, and it is better you do it when you are very conscious, you know. Some people rush and sign wills when they are on hospital beds. Those are grounds of invalidation. Or when they are too old and semi-senile, you know, great-great-grandmother, those are grounds that anybody can invalidate. So it's important that you must be in a sound state. You must do your will voluntarily without coercion, and it must be your best wishes. Then, of course, the other thing you must know that under the will, you must appoint executors. Executors are those people whose role is to implement your will, okay? And they need not to be the witnesses, and sometimes they are not. But the key point is that they must have the ability to execute, meaning, for instance, if you have property in, my name is Francis Gimara, and I have said that they are going to my daughters, it is their duty under law to ensure that because you can't sign a transfer, they go onto the title by fact that they are executors and then effect the transfers to my children in that case, so they can even be your children themselves. So you need to appoint executors. If you have property, you need to describe the property very well, and only property that is owned by you. You can't will property not owned by you. You must be a legal owner 100% under the laws of the country, okay? You must describe the property well, okay? And I think those are the key things. Effect of leaving out certain property in the will, these ones, that property will be dealt with intestate. You get it? As if the person did not die with the will, only that portion which is not willed, okay? But the portion that is willed, it's like that. But also, the will must always have a date, and it must state that it is your final will, such that if another one came, which was much earlier, and the two are presented, then the one with the later date will be taken as your final will. And you can always amend it when you get more property or you get more blessings. You are allowed to amend your will and add, you know. But clarify marital status, children, be detailed with these things, you know, so that even your burial ceremony, some people don't want a lot of drama around their burial ceremonies. We have seen, you saw an issue the other time which went to court where the man had told the wife that I want to be buried in our farm here in Uganda. And the relatives were saying, no, you must be buried home. You know, it was a contestation. I mean, the classic one is the one of SM Otieno in Kenya. It took many years in court because, you know, the wife had him buried in his farmland, and the Luo elders of Kenya insisted that he must be buried in accordance with the customary norms of the law. It was a big interstate dispute in Kenya. and makes quite some interesting reading. And again, it emphasizes the importance of just, you know, doing a will, even if it's not for property, but at least how you are buried, to give your loved ones chances to bury you in dignity. So I think that is it as far as the will is concerned. There's an issue as well of customary hair. This is just a hair to reflect the clan things. A customary hair is not really one who takes over your estate, you know? It's just somebody to represent you in cultural meetings, all those things, you know? You can state it in your will, but also indicate how they can manage what they are entitled to. Yeah, Rosemary, over to you.
Thank you very much, Francis and Judith. I think we are coming to a close, but I'll just take one. There are two questions, last questions. Francis, you mentioned that when you're, as you write in the will, the tips you gave, you said only describe property or I mean, give out property that where you own it 100%. Now, what happens in a situation where you and your spouse own this property and one party is writing the will? So I don't mention that property because I don't own the 100%. So throw more light on that. And then there's a question here from Robert Mande. Our father did not share anything, but requested us to work together. But our elders went ahead and to sell over 2 square miles without our presence. How do we get this land back? And then JB is saying, what if the witnesses are also dead by that time? Does this make it easy for a will to be challenged? And then one final one from me, I'm asking, supposing a family, a couple is living together, they are not divorced, but they are separated for all intents and purposes. They are estranged, and it's probably general knowledge that they are not, you know, living as a couple, but they are in the same home and they are not divorced. What happens if this person, one of the spouses, goes ahead and writes the will and excludes the other person? What takes precedence? What he has written in the will, even though it is unfair based on the circumstances, or would the law then come in? Over to you. I think those are the questions that we will. Okay, then the last one here from Ivan says, if I write a will, can I include a clause that my property should not be sold off by the beneficiary? How best can this clause be put to be legally enforceable? Thank you. I think those are the questions for the morning. So over to you, Francis. Respond to those, then we shall. If there are any other questions, please just keep putting them on. These can be responded even after this session, can be responded to even after this session. Over to you, Francis.
Thank you. If the property was purchased by both parties and it's only one who wills that, you see, the law is also based a lot on evidence. If I buy property with someone and I will all of it, but there is evidence, I can challenge for my portion of property and the court will grant it to me as long as there is evidence to that effect. The key thing in a will, you only, and that is why you are given 14 days to show up and register your interests. The key thing when doing a will only property that is yours. If it is owned jointly with your wife and it's not matrimonial home, because the law has a way it deals with matrimonial home, you then agree, you know, that I bought this property with my wife, we are joint tenants, and that takes effect. If it is joint tenancy, that means that the legal incident is different. If it is tenancy in common, the estate can inherit. There is one where your estate can inherit, and then there's also another one where if you die, you know, it goes to the other person. That is why whenever you are buying property with your husband, indicate, you know, how you want it. Do you want it to revert to him or her when you die, or you want it to revert to your estate? And then when you want it to revert to your estate, then you deal with it in a will and provide specifications for that. So it is important to be very clear, but the key point is you can only will your property. And then somebody asked about challenging if you know the executors, administrators. First of all, under the new amendment, if you are an executor or an administrator, you are now required to, to settle the estate within 2 years and to report. What has been happening in Uganda is very unfortunate. A person is appointed an administrator and they become an owner, or an executor, they become an owner. They forget that your appointment is to settle the estate, in accordance with either the law, if it is intestate, or in accordance with the will. So many people have been 5 years staying with the letters of administration or letters of probate. That is illegal. And one of the reasons why the Succession Amendment Act was strengthened in that regard is to require you to perform that role within 2 years. If you need another 2 years, then you apply in court. So if there is anyone who still has not settled the estate and you are holding letters of administration or letters of probate, please proceed and settle the estate in accordance with the law, or in accordance with the will, or in accordance with the law if it is intestate. There is no place for an administrator to keep managing the estate 5 years or so. Of course, if there is abuse as a beneficiary, and I understand the person who asked is a beneficiary, they can have recourse to court, to hold the parties abusing the estate to account. So there is a remedy. But also the law now says you cannot sell estate property, without the consent of the beneficiaries. So every time now you are buying from this law, every time you are buying land, estate land, please ensure that all the beneficiaries consent to that. If they don't, then that purchase will be invalidated for violating that. I think those are the questions. If witnesses are dead, it does not invalidate the will at all. The witnesses are just to satisfy that ingredient that they witnessed. You can call in other evidence to that effect, and somebody can come from their estate, if it is being challenged, to say this is our father's signature. Indeed, he was the witness,
Okay.
Then, Robert, I think Robert asked a very specific question. I've answered it generally to say that a beneficiary has rights, to hold those who are managing to account, the sale of the 2 square miles, was it used for the benefit of the beneficiaries? How was it done? Like we've said, the law now, though of course it saves actions that have been done 3 years from now, but under generally the legal framework, Robert, you can hold those people to account, and it will be your legitimate right as a beneficiary, right the wrongs that have been committed.
Okay, thank you so much, Judith and Francis. This has been an excellent, excellent presentation, very informative. And I think we are now forewarned, and therefore we are forearmed. And what we take away from here is the need to have a will. I think that is very important, but also how to do succession planning in our businesses, not just the will writing, but to ensure that this asset called your business actually grows and grows, and that as you think of putting it into your will, there is a lot. Because for the Christians, the Bible says a wise man leaves an inheritance for his children's children. And so that means we have to combine our hard work with our vision, with planning as well, so that we are able to live in peace, but also leave those behind in peace, to avoid situations where there is conflict, there is lack of clarity. You've worked so hard, but what you've worked for has all gone down the drain. So I would want to really, as we come to a close, to sincerely thank, if there was a way of putting our hands together, we'll put our hands together to Senior Advocate Francis Gimara and Judith Adobo for such an excellent presentation. And thank you too for accepting to share with us a format for the will. And I want to believe that each one of us here is going to go back and sit down. If you have no will, if there's nothing else you can take out from this session, is to go back and write a will to avoid a lot of problems that are associated with interstate dying. But also, let's go back and look at our businesses and look at those 6 pillars that have been shared. Human resource, talent acquisition, retention, and development. What are we doing? What business systems are we putting in place to make sure that our businesses actually grow, to make sure that we are replaceable? Clearly, we are replaceable. We are immortal, but it's up to us to take this in and break culture and go forth and talk about what will happen to my business without myself. I think that very soon we are going to come back with another session that we ran it some years back, but it's a session that says the man with the key has gone. Again, related to this, many of us tend to still stay in charge of this thing. Your business has grown, the business is crying for systems, the business is crying for more hands on the job, but you find yourself continuing to do this on yourself. So I think those are sessions we are going to bring back. There's a hand up from James Bumba. If it's burning, I'll give you an opportunity to speak, and then we bring this session, this excellent session, to a close. We will share the presentation, but also keep checking your messages, because next week, every Thursday, we run these business recovery sessions. We are going to have another excellent speaker on an aspect of business. We shall share the topics that will be discussed. And please share also within your networks, because this knowledge is power. When we get this knowledge and keep it to ourselves, we are not helping those around us. So share widely. Next Thursday, make sure same time you're available to listen in more. But also, we offer a complimentary business health check or business diagnostic for those who attend these sessions. So after this session, if you feel my business has issues, call us in. We will give you a complimentary business health check. We'll send some business counselors or advisors to your business to examine the pillars of your business and see how does succession planning look like within your business. So again, sign up. Send us an email or send us a WhatsApp or send us or give us a call, and we should be able to schedule business advisors to come to your business and give you this free diagnostic, because then this helps you to know where you are and therefore to plan for the steps ahead for your business. Okay, so James Babumba, are you still on? Your hand is up, or if you're up, you can make your last comment as we close. Okay, all right. I think he's not on. And so, ladies and gentlemen, I want to take this opportunity to thank you all for sparing 2 hours of your time to acquire this knowledge, and to implore you to go back and act on some of the nuggets that you have picked from today. I think that Francis and Judith have shared such critical insights that would help us, if applied, to move our businesses to the next level. So a big thank you to Judith Aboto, a big thank you to Council Francis Gimara, and a big thank you to all of you, ladies and gentlemen, in your capacities for attending this session. And we look forward to having you on call again next Thursday, same time, same place. God bless you all as you go to build this empire that you will pass on to your children's children. Thank you very much. Oh, sorry, Bumba was saying he couldn't unmute. I'm so sorry, Bumba. I have closed the session, but let me see if I can unmute. Sorry about that. Oh dear. I can't catch you. My co-host, can you see Bumba? If you can see James Bumba, please unmute him. Ronald, can you see James Bumba there? I'm sorry, James, I can't seem to see, but so have a pleasant day and feel free to.
Okay, I've been unmuted.
Okay, all right. Oh, thank you.
Okay, my question is it possible, if I don't want my estate to be subdivided and I will it to my people in percentages, Is it possible?
Okay, do we still have council, our councils there?
Yes,
Francis?
the short answer, it is possible. In fact, it is recommended. Sometimes I think the president has been saying that message that don't divide the assets. You know, if they are business assets, you think the children can keep together, because if you plan, you do proper estate planning, James, you can include that in the will and it will be respected.
Okay, thank you very much.
Thank you.
All right. Thank you, Francis. I think that you've addressed all questions. Any other questions that will come, we'll share them and we can respond individually. But generally, the compliments have been really good. Everybody truly appreciates the session. It's been very very informative. A lot of information you've shared, and we believe that it's going to transform our businesses. Have a pleasant day, ladies and gentlemen. Feel free to log out. God bless you. Lots of love from Enterprise Uganda team.
I have shared the link for those who want to register for the business health checks in the chat.
Okay, so go into the chat and get the link where you can register for the complimentary business health check that Enterprise Uganda is willing to perform on your business. And we should be able then to reach out to you and be able to support you along those lines. Thank you. Great session, great session, great session. Thank you so much. Thank you. Have a pleasant day, ladies and gentlemen. This is truly appreciated. Thank you. Thank you. Eye-opening session. Okay.